McGinty, you're muted. If you unmute yourself, we'll proceed. Call the matter of Ms. Lou Florence. Matter set for review. I guess the issues are the existence of a new DUI citation in Lakewood and compliance with the SOC in April. City of position. Mr. McGinty, I'd like to hear from you. What would you like?
Yes, thank you, Your Honor. And first and foremost, thank you for letting me appear via Zoom this morning. I have a very difficult calendar ahead of me, but the other matter in Lakewood, I represent Mr. Florence on that matter as well. We are scheduled to set a trial date on the 9th for that matter. So we're asking to set this matter over, if maybe we can set it over 60 days or so. That should be a sufficient amount of time. I think the Lakewood court is only holding trials once a month on a very specific calendar. So I don't know if we're gonna be able to get in next month or possibly even the following month, but I'll have a better idea by then.
Pierce County, I'm familiar with that.
Yeah.
Mr. Radfield, any objection to resetting the matter to today, February 27th or March 13th? No. Mr. McGinty, what works best for you?
March would work best for me, Your Honor.
Mr. Florence, we're going to reset the matter to March 13th. Conditions of the SOC still remain in effect. Maintain contact with your attorney and be back here on that date. And hopefully, we still have a decision to confer regarding how we're going to address.
Thank you very much, Your Honor. We appreciate it. Thank you, counsel.
Signing an order resetting the matter for that date. We'll be sending you a copy, and Mr. Lawrence, you can get a copy of today's order by going to the window outside the courtroom to your right before you leave. Any questions at all?
No, sir.
Take care. Happy New Year to all, and see you back here in March.
Thank you, Your Honor.
Thank you. That off record? Well. Okay. The jail is ready. Off record, jail is Happy New Year to you. I think we have some in custody hearings. I'll defer to you for the order.
Morning, Your Honor. I think I've turned the microphone on, so hopefully you can hear me here. This is Paul Harvey Scott.
Scott, good morning. For the record, your full name is Paul Harvey Scott. I'm going to want Mr. Haverco to represent you in this matter. Mr. Haverco, I'll turn to you.
Thank you, Your Honor. So this is Paul Harvey Scott. He has two matters that are coming on before the court this morning, both for an arraignment. One being a charge of criminal trespass, second degree. The other one being a reckless burning in the second degree. I've had an opportunity to review the reports with Mr. Scott and discuss the matters. And we've discussed what an arraignment is, the right to be read the charges in open court, the maximums that could be imposed. He'd like to waive arraignment on these matters, and the agreement is that he is going to enter a straight plea to the criminal trespass second degree charge. And then upon the court's acceptance to that plea, city will move to dismiss the reckless burning charge.
Scott, do you disagree with anything at all that Mr. Haverco just said?
What's that? No, no.
I'm looking at a statement dependent on
I turned it up to the max.
criminal trespass second degree is a misdemeanor. The maximum penalty on conviction would be 90 days in jail and or $1,000. I would be free to impose that if I saw fit, regardless of what's being recommended by the parties. You realize that?
Yeah,
If I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply sentencing.
okay, yeah,
As to one count of criminal trespass, alleged to have occurred within the city of Yelm on December 17, 2024. How do you plead, guilty or not?
Kelsey,
Do you make that plea of your own free will?
yes,
Anybody make any threats or promises to you to make you plead guilty?
no,
You will find the plea to be freely, knowingly, and voluntarily made, and your statement, paragraph 11, does satisfy the factual elements of the offense. Mr. Haverco, the recommendation is some adjustments are being made there. Mr. Harvey, if you can hear me, is there anything you'd like to tell me?
yeah, I was just, I was walking through, the property. I just will go around. I won't take the shortcut, and so I apologize for that.
Mr. Harvey, I can't count how many times you've spoken.
Yeah, do that. This is almost.
Offenses of that nature.
Why can't we just attach a speaker?
Did you have anything to add? Yeah. Mr. Mr. Harvey, one of these days, you're taking the chance, and it's simply gonna give you 90 days in jail out of just pure frustration. You just keep winding back in the same old place. I'm not going to also spend 90 days this time on the condition you have law-abiding behavior. But I don't know what it's gonna take for you to refrain from offending, but please, I'm gonna suggest maybe you address the substance issue. Good luck to you.
All right, thank you.
We're gonna switch computers, Your Honor. The sound here is not real good.
We'll stand by.
Yeah, thank you, Judge.
Back on record for the jail. Mr. Abaco, I can now see the corner of you. Are you able to hear me?
I am now, yeah, Judge. I was able to turn it up here. They do have They need to kind of enhance their speaker systems over here. They're not real good, but this is adequate. So this is Kevin Jones. He comes on before the court this morning for an arraignment on a criminal trespass second degree. I've gone over the police report with him and discussed the case. He'd like to waive arraignment and enter a plea to the charge. Recommendations in the nature of credit for time served and release.
Mr. Jones, for the record, is your full name Kevin, middle initial J. Jones?
Yes, sir.
Jones, I am appointing Mr. Haverko to represent you in this matter. Do you disagree at all with anything he just said?
Excuse me, say again, please.
He's indicating that you're going to waive arraignment and enter a plea to the charge.
Oh, yes.
I'm looking at a statement of defendant on plea of guilty to one count of criminal trespass second degree. Plea form tells me you're 37 years of age. Any problem at all reading, understanding, going over the plea process with Mr. Haverko?
No, sir.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to 90 days in jail and up to a $1,000 fine, regardless of what's recommended here. If I saw fit to do so, you realize that.
Yes.
As to one count of criminal trespass in the second degree, alleged to have occurred within the city of Yelm on December 15th, 2024, how do you plead, guilty or not guilty?
Guilty.
Make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty?
Sort of. I mean, not anything that's not anything I'm gonna charge or anything over or anything that, or
Freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements. It is important that I understand that you weren't coerced or promised anything that you shouldn't have been. I still have the right to impose whatever sentence I think most appropriate, regardless of what's recommended. You know that.
yes, sir.
Mr. Haverko, anything further?
Nothing, Your Honor. The city's recommendation is credit for time served and no financial obligations. Would ask the court to follow the recommendation.
Bradfield, the city have anything further? Nothing. Mr. Jones, anything you'd like to tell me?
No. I don't think so. Well, not over the camera, of course. Maybe in person. You know what I mean? Later time.
In person, I'm hoping that won't take place. I don't like to keep people in jail. I look at your record here, and I think that I told you this when we spoke, that this is the 30th time that you've been cited by a young police officer. You've had problems elsewhere, but that's a lot of times to be getting in trouble, okay? Mr. Jones, the criminal law is very simple, actually. It comes down to two things. Don't hurt other people and don't hurt other people's property. And that's, and you're continually being accused and cited for violating that second precept. I'm going to wish you the best of luck and realize that all you have to do is just stay out of trouble.
Okay.
You're not supposed to go. Is that too much to ask?
No.
Unless you have some other hold on you, you'll be released today. I'm going to wish you the best of luck, Mr. Jones. You take care of yourself. Again, 90 days, all suspended on the condition of law-abiding behavior. I'm not going to impose any fine given your financial status. Good luck.
God bless you. Thank you.
Thank you, Mr. Jones.
Seat in the hot seat. Morning, Your Honor. This is Aiden Conlon. matter comes on before the court this morning for an arraignment on a DUI. We're ready to proceed with arraignment. And then we would also at some point like to address conditions of release.
Take the court's full name, Aiden Sean Conlon. Are you?
Could you speak up a little bit, Your Honor? We can't really hear you.
I'll give it a try. Is your full name Aiden Sean Conlon?
Yes, Your Honor.
Citation alleges that on or about December 27th, 2024, you committed the offense of driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you for purposes of this hearing only at this time to enter a plea on your behalf. Mr. Haverco?
Thank you, Your Honor. I've reviewed the report. I've had an opportunity, by the way, to review the report, the defendant a little bit, and stipulates probable cause. I'd ask the court to enter a not guilty plea.
Plea of not guilty does preserve your rights, Mr. Conlon. And Mr. Haverco, I turn to you for...
Thank you, Your Honor. Aiden lives with his parents. I was provided a phone number for his mother, Robin. I was able to speak with her, and she's taking a lot of efforts on the outside of jail to arrange a chemical dependency evaluation, which we really need to get one in this case in order to move forward in some directions we've discussed. He lives locally at at an address in Yelm. He does have employment, works for a company that builds docks and piers. And I have discussed this matter with him. He does appreciate, the seriousness. It may look to the court as though he doesn't, but I've discussed it with him, and he does take this matter very seriously. He really appreciates the trouble that he is in. He says to me he is sincere about getting evaluated and really trying to now take this chemical dependency issue seriously. We're talking about how so far his mom, I think, has called 3 or 4 chemical dependency treatment providers, so far of which would not been successful at arranging an evaluation at the jail. Not that that's not possible, but so far it's been difficult. There's been no success, and so I would like the court to maybe perhaps consider releasing the defendant on the condition that he, within a short period of time, show proof to the court that he's wearing a scram device that would detect, and get him in trouble for any reported consumption of alcohol. And because, if he were released, he'd be able to forthwith, get an evaluation and get that accomplished, and we'd be able to kind of move the case forward because we have a pretty good idea of what we're likely going to do. So that's kind of the dilemma. Is I understand the court's concern about public safety, but my thought is that perhaps on the earnest representation that he's serious about taking care of this and would, obtain a scram device immediately. And at least he does have the assistance of some parents that seem to be interested in him and care about him. And so, like I said, I spoke with his mom, and she's real concerned about him and wanting to try to help him in the right direction. So I'd ask the court to reconsider the release conditions.
Did he have a position? Mr. Conlon, the breathalyzer taken in your recent case was reported to be 0.22, which is extremely high, and indicates a number of things that I won't go into at this point. When we spoke on the phone, I definitely had the impression that you didn't quite get the seriousness of what was going on here. You're becoming a poster child for the person that winds up in the county jail facing a charge of negligent homicide, assault, any one of a number of other things.
Your Honor, I understand the seriousness of it, and that's why I want to do the program and give me like 100% silver. I realized I just want to get 100% silver.
You at this point, Mr. Atfield, Mr. Conlon is on an SOC earlier this year. The city orally moving to revoke that at this time, or
City not really.
Mr. Conlon, I'll take a chance. I'm going to release you on conditions. Again, the ones we spoke about. No criminal law violations, and I want you to install ignition interlock in your car and file proof of that. I'm going to set your next hearing for the 13th of January. That's on a Monday. I'll leave it to Mr. Are you you were represented by private counsel the last time you were in court here. Are you going to retain counsel, or is Mr. Haverco going to represent you in this matter? Where are we there?
I believe he's going to represent me the rest of the way.
If you're indigent, I'll appoint him to represent you, and I'll leave that up to Mr. Haverco to determine that. But I'm taking a chance here. There's a lot of judges that wouldn't, given
I appreciate it.
reason. You can show your appreciation by staying out of trouble and doing whatever you need to do. I'll leave it at that. That's unless there's some other hold on you, let's say you'll be released on your own recognizance with your promise to appear. And I definitely want ignition interlock in the car. Yeah, that's no drinking and driving, period, and no consumption of alcohol, period. That's alcohol is not proving to be a very good friend. That's of yours. I'll leave it at that. Send out an order that should be out of there before too awful long, and you need to abide by the conditions. Good luck. We'll see you on the 13th. That's a week from this coming Monday. Take care.
Thank you. Thank you, Your Honor.
Thank you, Your Honor.
Yes, actually.
Hearings he's being released on the it's in there. I'll just hope the jail gets that.
The hot seat.
Oh, yeah. Oh, yeah.
Good morning, Your Honor. This is Michael Lewis. This matter comes on before the court for an arraignment on the charge of assault fourth-degree domestic violence.
Good morning, sir. Is your full name Micah, middle initial W, Lewis?
Yes, sir.
Mr. Lewis, the citation I have alleges that on or about December 19th, 2024, you committed the offense of fourth-degree assault domestic violence. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you in this hearing, and he's going to enter a plea in your behalf at this time. Mr. Haverco?
Thank you, Your Honor. I would stipulate to probable cause and ask the court to enter a not guilty plea, and then also would like to address release conditions.
All right, I'll hear from you at this time.
Thank you, Your Honor. So I realize we have a situation here when you look at his criminal history. On the one hand, there is no, technically, there are no convictions. However, this is the third charge in the course of about 3 years. I would ask the court to entertain his release. I would understand if the court had concerns about releasing him to where he could return home. He indicates, first of all, he's retired from the military. He spent 20 years in the military, retired as an E7 sergeant, and he currently works, he has a job, currently works for something called the Central Issue Facility, works as a civilian at JBLM. So he's a productive individual. He's engaged with employment, providing for his family. I was asking him, if the court did release him, would he have a place to go, other than going back home? And he did indicate he could stay with his boss. His boss, her name is Shelley Johnson. And he does have appointments with the Veterans Administration to deal with some alcohol issues. And so I think the issue here is not so much general public safety, but safety from the court's point of view concerning the alleged victim in the case. And so I would ask the court to release him on his own recognizance, just with a proviso that if the court feels it's appropriate with respect to contact with the victim or not, if he is able to stay somewhere, if the court's concern is to stay away from the victim, if he can stay somewhere else, I would ask that the court just release him on those conditions and otherwise on his own recognizance.
Bradfield, no. Mr. Lewis, accept the plea of not guilty. Going to set the matter for a pretrial on January 13th. Given the history here of 2 prior arrests for same victim, same assault, same charge, and the new one, as the allegation is the victim was struck hard enough to split the head open to the extent that stitches were required. I'm going to leave bail the way it is until the 13th of January, and we'll review the matter at that time. I want to know a little bit more, and the city will probably need a chance to discuss the matter with the alleged victim in here. I am entering a formal no contact order. That order will be served on you by staff at the jail there. You need to review that order very carefully. Violation of a formal no contact order is a very serious thing. Conditions release, as earlier said, remain the same, and they include no consumption of alcohol of any kind and no contact at all with Christine Wanjala Lewis. That concludes the hearing.
Thank you, Your Honor.
Thank you, Mr. Evercole. It's not finding in the, here we go. Oh. Looks like, sorry. Donnie, if I order, finally got down to a little alpha. I need to set up. Just these forms are. We do have 9 o'clock hearings. Good morning, Ms. Lazarek. I see you're present. We'll address your matter now.
And good morning, Your Honor. I'm here on the Mancinelli matter, and she is present in the courtroom.
Good. Come on, ma'am, if you would, and have a seat at the council table and speak into the microphone. Matter set for a pretrial hearing at this time. Turn to the parties for the status of the matter and what we're doing here.
And good morning, Your Honor. Attorney Kate Lazarek on behalf of Ms. Mancinelli, who is present in the courtroom. This would be a defense motion to continue. This is our first pretrial. I have reached out to the city. We are in active negotiations. So just more time for investigations and negotiations. I have gone through a speedy trial waiver with Ms. Mancinelli and have added that to the motion to continue. And we'd just be asking for it to commence at the next court date, February 13th.
Hearing no objection from the city. For the record, your full name is Maggie Elizabeth Mancinelli. If I mispronounce your name, and I'm prone to do that, I apologize.
No worries.
At the request of your attorney, we're going to reset the matter to February 13th, conditions release or any earlier set, and stay in touch with your attorney and appear back here on February 13th. I'm signing an order resetting the matter. Till then, you'll be able to get a copy of it when we go into recess at the window outside the courtroom to your right. Ms. Lazarek, any questions or any objections?
No objections, no questions. Thank you, Your Honor.
We'll be sending you a copy of today's order as well. You take care. That concludes the hearing.
Thank you. Have a good morning.
I've now signed the order. We're a little, it being the day after New Year's, a little shorthanded. Get a copy of today's order at the window out and to the right. Good luck to you and thank you.
Your Honor,
Oh, sure. We do have, I think, we'll need an order for Rivera, Thomas Rivera. But yeah, but go ahead if you've got something, okay, something to take care of. We'll take care of that later. I'll sign we're still on the record. I will sign orders resetting. Okay, yeah, bring up, Ekaterina. Gugutlova.
Good morning, Your Honor.
Good morning. We'll address your matter now.
Yes, Your Honor, thank you. I'm standing in for the attorney of record, Austin Ansing, for Daniel Barriga, and I'm appearing pursuant to 3-4, Your Honor. Mr. Ansing has been in good communication with his client. He has reviewed the speedy trial waiver, which was filed with the O court. At this time, Mr. Ansing is respectfully asking for a continuance. He needs additional time to petition for a deferred prosecution, so just needs to get some paperwork going, Your Honor.
I have no courts in order resetting the matter to February 27th. I'm going to sign the order, hearing no objection from the city. I'll be sending, you're in touch with the client, Mr. Barriga.
Mhm.
We'll be sending him a copy of today's order as well as Mr. Ansing.
I appreciate it, Your Honor. Thank you.
That concludes the hearing, and Happy New Year to you. Take care.
Thank you very much. Thank you. Have a good day, Your Honor.
Thank you. Good. That would be Mr. Crone. Oh, Mr. Jagley, probably standing in for. Good morning.
Good morning, Your Honor. Just
Take
to let
care.
you know, I can barely hear your audio, so I may be sticking my ear up to the screen there. But I'm here for on the Christopher Bertrand matter, and I'm appearing on behalf of Attorney Jay Crone.
I see a motion for continue within in the O court system, request to reset to January 30th. I take it that's a request of counsel.
That is a request of counsel, Your Honor. We've had some difficulty contacting Mr. Bertrand. He's had some pretty severe personal issues going on. I believe his father passed away very recently, and he's been in and out of the hospital a bit as well himself. And he's down in California helping his mom deal with the overall situation. So at this point, we just asked the court to just note an FTA, set it over to January 30th, and we can make this an excluded period for speedy trial purposes.
That's exactly what I'll do. Note the non-appearance for speedy trial purposes only. Reset the matter to January 30th, and we'll send Mr. Bertrand a copy of today's order as well as Mr. Crone.
Great, thank you, Your Honor, and I can get that off of O Courts as well and get that sent out to everyone.
Perfect. You take care. Happy New Year and have a good day.
Thank you, Your Honor. You too.
Well. I forget, yes, with this new technology, they can simply pull the order off We do. Back on record, we do have an attorney on. We'll let them appear. Good morning,
Good morning, Your Honor.
Real. We'll address your matter right now. You can now hear me.
Yes, I can hear you. My apologies for being a little bit late this morning. So sorry, Your Honor.
It's the day after New Year's Day. Yeah, a lot going on. Too much so.
Too much.
Go ahead. I'm looking at in courts at a motion to reset Mr. Rivera, your client, to January 30th.
Yes, Your Honor. I'm sorry to have to reset this again. Your Honor, I'm waiting on my client to get relicensed. He is working on it. He's had some unfortunate financial issues, which is pushing him back a little bit. So I'm hoping just give him about 30 days here and see what we can do before the 30th.
Hearing no objection from the city, we'll do exactly that. And that's, I think, really what we really care about here is people getting relicensed. Signing the order at this time. We'll send you a copy of the order and as well as to Mr. Rivera and wish him the best of luck in getting reinstated.
Thank you so much, Your Honor. Have a good one.
And you too. Happy New Year. Take care.
Happy New Year. Bye.
Now on record, Mr. Haverco will call the matter of Yelm versus Jose Hernandez, who is in the courtroom and next to you. He's here to request that a warrant be quashed.
Yes, and that's the request. He comes on to quash this warrant. The matter was previously on for a pre-trial hearing, so I would ask the court to quash the warrant, reset the case for another pre-trial.
Mr. Hernandez has failed to appear on August 15th, October 20 of 24, and November of 07. This November 7th. 3 non-appearances. Mr. Hernandez is they seem to have trouble getting you to come to court. Very important that you stay in touch with Mr. Haverco and make it to court. Maybe he can call you the day before court or the morning of court. Make sure you get here. Let's reset the matter. Mr. Haverco, how far out would you like to go?
Oh, just ordinary course. Do you have a phone number still, or?
Reset to the 13th.
Okay. All right.
Mr. Hernandez, we're going to reset the matter to January 13th. That's a Monday, not a Thursday. That's the number. Stay in touch with Mr. Haverco and make sure you're back here on the 13th, okay? Well, you're going to be able to get a copy. There's going to be a notice of hearing issued here, January 13th, 11 o'clock in the morning. What I want you to do is go to the window outside the courtroom and over to your right and get a copy of the notice and keep that where you can see it and remind yourself to come to court. If you have, and somebody is raising their hand in the back. Okay. Perfect. Perfect. Hey, thank you very much.
Yeah. Uh-huh. Well, he's welcome to call me. So who's the person you want me to call? He's your public defender at the county?
Yes.
Okay. Hey, does he have a phone number? Well, yeah, but I'm asking you again, so you don't have it? Okay. I'll see what I can do. Is he supposed to tell me anything in particular?
Yes.
Oh, where you're incompetent?
Yes.
All right. I'll see what I can do. I'll look it up. Okay. Well, why don't you take off, get your paperwork before you go? Okay.
January 13th, 11 o'clock. Hey, thank you. Mr. Hernandez, you've got a friend that's going to help you out here with this. Stay in touch with your friend and thank you for appearing.
Mr. Debonair.
Good morning, sir. His full name Nicholas, middle initial M, debonair. Okay. Matter set for pretrial. I'll turn to your attorney for the status of the matter. Sign on this pad.
So, yeah, this is Mr. Mikolas, debonair. Matter comes on for a pretrial hearing on a DUI charge. Parties, I believe, have an agreement, that being a stipulated order of continuance in O courts, matter to be continued for 2 years on the standard DUI related conditions. Reduction to negligent driving in the first degree if he abides by those conditions.
Did he have anything to add? Mr. Debonair, I'm looking at the SOC, stipulated order of continuance. It's a rather lengthy argument, but it's an agreement, contract between yourself and the city, negotiated by your attorney, under the terms of which 24 months down the road, this charge can be reduced to a much less serious charge of negligent driving in the first degree. The most important part of the agreement is no alcohol-related offenses over the next 2 years, and B, get a drug and alcohol evaluation and comply with any recommended treatment within the next 90 days. That's in the agreement. The whole thing, what we're about here is, hey, if there's a problem, let's deal with it and make sure there isn't any repetition. I've already dealt with one case today where somebody just a few months after one DUI got another one. You don't want to go there. We want to, if there's a problem, let's deal with it. Let's fix it and go on with life. The conviction of a DUI is terrible. And in terms of impact on your life, it's worse than a lot of felony convictions. Now, if you violate the agreement, in return for the agreement, you've given up your right to go to trial, have witnesses. If the city proves you violated the agreement, we'll have a hearing based on the police report, and that would almost certainly result in a conviction with all that goes with that, the possibility of a lot of jail time, license loss, et cetera, et cetera. I'm going to wish you the best of luck. What I want you to do is get a copy of today's agreement at the window outside the courtroom and to your right. Look it over carefully. Make sure you understand fully what the agreement entails. And if you have any questions about what the agreement means, give Mr. Averco a call and make sure you're real clear on that. That's pretty important. I'm going to wish you the best of luck. Mr. Averco has put you in a position where you can minimize the damage of the event that led to the charge. But I'm looking at the person that's responsible to take advantage of that. I'm going to wish you the best of luck. Take care of yourself. Thank you, sir.
Okay, good luck. Mr. Michaelis.
Mr. Michaelis, good morning. So far, so good.
I'm right there. There is a motion to continue in Oak Courts.
About how far out would you like to go?
I'd ask 4 weeks. There needs to be an evaluation. Takes a little bit of time.
January 30th, February 13th.
January 30th is fine.
Mr. Michaelis will reset your matter to January 30th. In the meantime, stay in touch with Mr. Haverco, and any conditions earlier said, they remain in effect. Any question at all? We're preparing, and I will sign off on an order resetting the matter to the end of January.
You've already signed.
Any question at all? I'm going to wish you the best of luck. Get a copy of today's order at the window outside the courtroom and to your right, and we'll see you back here at the end of the month.
Thank you.
Thanks for appearing.
Good day.
And you as well.
And the only other person here that I need to talk to is Mr. Ehrlich.
Mr. Ehrlich, good morning. Traffic go back on record. I'll defer to
Judge.
you for the order in which the calendar is called.
Fine here.
Morning, sir. And for the record, your name is Thon Pai Ehrlich. If I mispronounce, I apologize.
So he's got three matters on this morning, a couple of which are pretrial hearings. It's got a mitigation matter as well. Parties having a proposed settlement here. He's going to, on the case ending in 409, item number 3, he's going to enter a plea to count 2, false reporting, dismiss count 1 on plea. He'll also enter a plea to the obstruction under case number 732. So pleading to 2, dismiss 1, and then also the city will agree to dismiss the mitigation matter.
Mr. Ehrlich, do you disagree at all with anything Mr. Haverko just said? I'm looking at a statement of defendant on plea of guilty to 1 count of obstructing a law enforcement officer on November 13th, 2024. That's ticket ending in 732. Also a plea of guilty to 1 count of false reporting, 3rd degree, on October 1st, 2024. Have you gone over the plea process with Mr. Haverko? Mr. Ehrlich, have you gone over the process with Mr. Haverko? Have you discussed how we're proceeding here with Mr. Haverko at all? I just indicated that the plea of guilty would be to 1 count of obstructing and 1 count of false reporting. Do you agree with that? Mr. Haverko, do you think we're ready to proceed in this matter?
Are you ready to proceed? Or what do you want to do? Need to speak up a little bit.
Pardon? Mr. Ehrlich, I'm hoping that you're paying attention and comprehending what's going on here. Each of these charges you're pleading guilty to is a gross misdemeanor. The maximum penalty for each would be 364 days in jail and or a $5,000 fine. You realize that? I would be free to impose that up to the maximum in each charge if I saw fit to do so, regardless of what's recommended. You realize that? Now, if I accept the pleas, you also give up the rights contained in paragraph 5. There's no trial, no plea, no witnesses, no anything except a sentencing. You realize that? You don't have those rights anymore. Oh, you will. Before I impose any sentence, you'll have a chance to tell me anything you think I should know. You'll have that chance. With that in mind, as to 1 count of false reporting 3rd degree alleged to have occurred within Yelm on October 1st, 2024, and 1 count of obstructing the law enforcement officer on November 13th, 2024. As to those charges, how do you plead guilty or not guilty? Guilty or not guilty? Do you make those pleas of your own free will? Has anybody made any threats or promises to you to make you plead guilty? You're doing this after discussing the matter with Mr. Haverko. To talk to Mr. Haverko a little bit more about the case? Yeah.
We can
Reset the
it.
matter to a future court
Yeah.
date? Why don't we reset the matter to the 13th or the 30th?
Sure.
What do you choose? What would you like? Either one or
either.
the other one. I think the 30th work better.
Okay.
Let's reset the matter to January 30th. I'm going to generate a notice of hearing. I'll want you to get at the window outside the courtroom to your right. In the meantime, stay in touch with Mr. Haverko. In any conditions earlier set or remain in effect. Stay out of trouble, no law violations, and show up for court, okay? No need to sign anything, or even make a note of it, Mr. Ehrlich. The notice that you get at the window will have the date and time of your next appearance. Good luck to you. You take care of yourself. We'll see you back here and on the 30th. Any questions? Good luck to you.
It's in the paperwork. I'll call you.
You have Mr. Averco's contact information? And he has your
Correct.
phone number?
Yeah.
Good. Go ahead and get the notice, Mr. Ehrlich, and we'll see you back here end of the month. Take care.
Ms. Perez? That's up to the judge. You understand what you're doing? Next matter on the 11 o'clock would be Danielle Perez. It's item number 8. Matter comes on for a pretrial hearing on assault, fourth degree domestic violence. We put in a stipulated order of continuance into O courts. Matter to be continued for 12 months on the condition she pay a $250 court fee, not commit new criminal law violations. There is an active no contact order on the case. The victim is here. And so we were wanting to address the issue of the no contact order, and we'll be asking the court to consider rescinding that order.
That was just a condition of release?
No, it's an actual
Was it
active
formal?
order.
No
It's a
contact
formal order.
For the record, Danielle Perez is your full name. Ms. Perez, I'm looking at a SOC stipulated order of continuance in the O court system. Have you gone over that agreement with Mr. Haverco? It's a contract between yourself and the city negotiated by Mr. Haverco on your behalf, under the terms of which 12 months from now, charge goes away. If you abide by the conditions set forth in the agreement. And those are very simple: stay out of trouble, no criminal law violations, and pay costs in the amount of $250. Most important being stay out of trouble. Any domestic issues are to be resolved peaceably and not bring you into court. Now, if you violate the agreement, you've given up your right to go to trial, have witnesses. If there's a violation of the agreement, and the city has to prove that by a preponderance of the evidence, if there is proof of a violation, our hearing will be on the police report, and you know what that would result in, the conviction of, and the possibility of jail time and a heavy fine. I'm going to wish you the best of luck with this. I'd like to hear from the
next
with regard to the no contact order.
I believe the victim this is the victim. She's present.
You're Ms. Hendricks? For the record, Amber Hendricks. Okay. You'd like to say something? I'll hear from you. Yes. Did you have any input? I am inclined to drop the no contact order. Hopefully this has been a learning experience. Every relationship has its ups and downs, its speed bumps, if you will, as we go through life. That's just the way it is. And it just, sometimes we have to learn how to deal with things in a very peaceful, rational manner, and realizing that things get pretty heated at times, especially if a relationship or life is under a stress. I'm going to sign an order rescinding the no contact order, and wish you the best of luck with each other and with life in general. Hopefully, and everybody should have a safety plan. Things do go south on occasion in life. So it's important to know, what am I going to do if things do? How do I keep myself safe? And that's the important thing here. That's the concern. Here is you have happiness together, if that's and the peace be maintained, that everybody stays safe. That's our concern here. I'm going to wish you the best of luck. I'll sign an order approving of the SOC. And again, you can look forward to having this matter dismissed if there's compliance with the conditions. And we're a little shorthanded today, it being the day after New Year's. So you're going to have to go to the window outside the courtroom and to your right to get a copy of today's orders, one rescinding. And since it's in the system and will be entered, probably a good idea to keep that, the order of rescission on you for a period of time anyway, until the system is sometimes a little bit slow. And I wish you the best of luck, the both of you. You take care of yourselves and take care of each other, okay? Thank you. Okay. Going to call the matter of Yelm versus Mr. Norton. Mr. Norton, I believe, is present on by way of Zoom, and he is present. Mr. Norton, you look like you're muted. Go ahead and unmute yourself if you would. Okay. Good morning, sir. Able to hear me now?
Yes, sir. Sorry, I've been sitting in here for like an hour. I got afraid you guys forgot about me.
Things take a little bit of time. Sorry for the delay, but we'll address the matter now. We're set for a sentencing on reckless driving and no ignition interlock. Mr. Haverco,
Well, I think
I'll
Your
hear from
Honor,
you.
I think Your Honor had set the matter over for sentencing because I don't believe Your Honor at the time, I think you had a question about his discharge summary.
I did.
Yeah,
I did.
and I
And we
believe-
now have that, and I've reviewed
Right,
it.
and I
Yes.
believe, yeah, when we have, we're ready to proceed with it.
Right. City, have anything to add? No. Mr. Norton, is there anything you'd like to tell me? You don't have to say anything, but if you want me to know anything about your situation or the case, now's the time.
This last year has taught me a lot, and treatment's done me a lot of good, and I'm ready to move on and do better with my life and make better decisions. That's all.
Mr. Norton, what I'm going to do is I'm going to sentence you to 364 days in jail. I'm going to give you credit for the time you served in Nisqually and the 28 days you did inpatient. That's a total of 116 days. I'm going to give you credit for time served. Suspend 248 days on the condition you have law-abiding behavior and be in full compliance with your any treatment program. When we first saw each other, you were at a place that I was pretty concerned about in life. You're well on your way to either winding up in the penitentiary for something really bad, or being in a position where you're never going to be able to get licensed, and you're going to spend a very considerable period of time in jail. You're not out of the woods, but you're on your way out of the woods. That, as far as I'm concerned, concludes this matter. In terms of a fine, is any fine being recommended here?
Well, I think, I don't know if the city's recommending the usual, I assume probably the usual DUI related costs, the $990.
Mr. Norton, are you working now at all? Do you have any source of income?
No, I do IOP 3 times a week, so it's kind of hard to maintain any kind of work. But as soon as I get done with the intensive outpatient, I'll have more time to be able to get back to work. And I'm also working on getting my custody of my kids back and the whole nine. So I'm just kind of trying to do it all at once.
I'm not inclined to impose any fine, given your situation here, and I believe you still have matters pending that have to be dealt with. That's going to be enough on your plate for now. But I would say you're at a point now where your life is going down a better path, so to speak. It's not going to be easy. It's not going to be easy. You've got other matters that got to be resolved here, and I'm going to wish you the best of luck with them. But as I've said many times before, it's not how many times you fall down, it's how many times you get back up. I'm hoping that you have some full appreciation of where you are in life and what you need to do to maintain your freedom and a good driver's license, etc.
Yes, sir. Yeah, 3 months in Nisqually was good for me. I don't want to do that again.
No. Don't blame me for that.
Yeah.
All I can do is wish you the best of luck, Mr. Norton. You take care of yourself. That concludes the hearing as far as we're concerned. Your obligation to us at this point is to not reoffend.
Yes, sir.
We'll be keeping an eye on that and wishing you luck with the other matters you have.
Thank you very much, sir.
We'll send you a copy of the judgment and sentence in this matter. Review it carefully, and if you have any questions, give Mr. Haverco a call, okay?
Yes, sir, I will. Thank you very much.
Take care of yourself.
You too. Bye-bye.
Mr. Williams, good morning.
I'll have to meet with him. I haven't talked to him. We are,
Okay.
yeah. Yeah.
Back
yeah.
on record for the pre-trials, Mr. Everco, again, I'll defer to
Yeah,
you for
thank
the
you.
order the
Yeah.
cases are called.
Mr. Let's see. On the 10 o'clock, Mr. Williams.
Mr. Williams, come on up and have a seat if you would. For the record, full name Robert Colton Williams. Good morning, sir.
Just give me one moment, Your Honor. Okay, let's see. So Donnie, on the motion to continue, should I delete that? Gotcha.
That's a new
This is the,
form.
This is the jury trial waiver, so sign here. Yeah. Oh, I'm sorry, got to plug it in, huh? Okay, there you go. There you go. Should be working. Oh, yeah, there it's, yeah, it's working. Okay. You sign that. And prosecutor has to sign. Okay, what else we got? The pre-trial conference. Document. Let's see. We'll sign. Now, sign. This is the pre-trial order. Dates. We won't sign. So, I've had an opportunity to review the different police reports with Mr. Williams, and there's still the potential that we could have an agreement at some point. We just don't have one today. And Mr. Williams is inclined at this point to submit a jury trial waiver. And with the potential of, we may want to go ahead and set a trial date now, a bench trial. And then, of course, we'd want to set a trial confirmation hearing. Let's see, let me just also double check, and I wanted to insert into the pretrial order. There's a waiver inside the, is there a waiver inside the pretrial order? Pretrial waiver? Oh, okay. Oh, okay. Oh, thank you. Yeah, and so what we might want to do, just also make sure to give Mr. Williams enough time to kind of really think things over. I would suggest, resetting the pretrial. Just having one more pretrial. And then at that time, we can either, well, actually, right now, we could still just go ahead and set a bench trial date out with a trial confirmation date. And then, of course, if we wind up reaching a resolution at the pretrial stage, then the remaining dates would be stricken. But it might be better just to go ahead and set a bench trial date. And
Well, I'm looking at this new form here. We haven't used the order on pretrial conference form yet. I noticed we could have a readiness, we could simply note a readiness hearing for January 30th. And if the parties have an agreement by that time, we can put it on the record. And if not, we can set a trial date at that time.
that's fine.
Is that gonna work? Stratfield? And
Yeah.
let's set a readiness hearing for January 30th. Yeah, Mr. Williams, deciding to go to trial, that's kind of crossing the Rubicon. It's something to be very carefully considered. This will give you a little time to work with Mr. Haverco to resolve the matter by agreement, if possible, and if not, get ready for trial. One or the other. Reset it January 30th, 11 a.m.
All right.
Mr. Williams, I'm signing an order to that effect right now. What I want you to do is stay in touch with Mr. Haverco, of course, and then get a copy of today's order and have the date and time of hearing on it before you leave. Any questions? Good luck to you. Any other pretrial conditions?
No other issues at this time, Your Honor.
Remain in effect, Mr. Williams, stay out of trouble and no drugs. You take care of yourself. We'll see you back here at the end of the month. Mr. Williams, and you as well. Take care.
Moving on to the 11 o'clock, Robert Clark.
Mr. Clark, good morning.
Parties have reached an agreement, that being a stipulated order of continuance. The matter be to be continued for 2 years on the condition that he abide by all the conditions stated therein. They're all DUI related conditions, evaluation, apply with any recommended treatment or follow-up, ADIS, if that treatment's not recommended, victim impact panel class, $990.50. And then at the end of the agreement period, if he successfully completes the agreement, then the matter would be amended to negligent driving first degree.
For the record, full name Robert Russell Clark. Mr. Clark, do you disagree at all with anything Mr. Everco just said? I'm looking at an SOC, which in reality is a contract between yourself and the city negotiated by your attorney where 2 years from now, a DUI charge can be reduced to and go on your record as a negligent driving first degree charge. That's a considerable reduction and means a lot in terms of insurance premiums, license suspension, jail time, et cetera. In return for the agreement, you've given up your right to go to trial, have witnesses, appeal if you lose. If there is a violation of the agreement, the city proves that, we'll have a hearing based on the police reports, and that would probably not go well at all. One of the other conditions of the agreement is a probation fee of $990.50. You can pay that $45 a month. Most importantly, there's a requirement of a drug and alcohol evaluation and compliance with any recommended treatment. Purpose of that is, if there's an issue here, let's deal with it, and so you're not back here on a new charge like this again, okay? Signing off on the agreement, Mr. Clark, I'm going to wish you the best of luck. Now, I want you to get a copy of this SOC at the window outside the courtroom to your right. Look it over, read it over carefully, and if you have any questions at all about what it means, give Mr. Everco a call, okay? Any questions of me? All I can do is wish you the best of luck at this time and hope that 24 months from now we can reduce the charge to much less serious. Good luck to you, Mr. Clark. Take care of yourself.
Yeah, just go to the police department before you leave and they'll give you a copy of the paperwork. Curtis Lopez.
Sir Lopez, good morning. Is it Curtis A. Lopez for the record? Correct.
Submitted a motion to continue along with a speedy trial waiver in O courts, asking to reset the case at least 4 weeks. The intention is to obtain an evaluation.
January 13th.
Sure.
Will probably be the best. Mr. Lopez, we're going to reset the matter to January 13th. Stay in touch
Well,
with
I'd
Mr.
ask for more time
Upton.
than the 13th. Yeah, I'd ask for 4 weeks.
4 weeks.
Yeah. Yeah, that 2 weeks is not enough to get.
Oh, I'm sorry, February 13th.
Yeah, that's fine.
February
Yeah, perfect.
13th. That's, I shouldn't think and talk at the same time. Need to finish this process before I put the mouth in gear. Mr. Lopez, any conditions of release earlier set remain in effect. Stay out of trouble. Stay in touch with Mr. Everco, and we'll see you back here February 13th and see how things are then. In the meantime, any questions?
No.
Good luck to you. We'll see you back here next month.
Next matter will be Tanner Lunsford.
Mr. Lunsford, Tanner James Lunsford. Go ahead and have a seat.
So I believe the parties reached an agreement. The city is going to amend the reckless driving to negligent driving second degree. And then amend the suspended driving third degree to no valid operator's license with ID, $150 each, which you'll admit.
Mr. Lunsford, I'm going to ask you as to the amended citations. They go from criminal offense to a civil infraction. Do you admit that on October 18th, you drove in a negligent manner, amounting to negligent driving in the secondary, and you drove without a valid license in your person? I'll impose a $150 fine. I remember the case. I remember the factual elements of the case. They used to use the expression, you have something of a leb foot. That's you're not doing your license any favors, and you're not doing your insurance premiums any favors at all. And that's there's an old expression, speed kills, and I've certainly seen that over the years. I've been in law enforcement of that happening. In fact, it happened to a fairly good friend of a fairly good friend of mine. His son, 18 years old. And my 19-year-old neighbor, 19 years old, speed killed them. Yeah. If you need to, racetrack is where to do that. That's we'll have you sign I will sign an order setting the disposition. And yeah, these things drop off your record given time. But slow down, get there safely, and it's not only the safety of everybody else out there; it's your safety as well. I'd hate to read your name in the paper or hear about it. I've certainly heard many names over the years. Don't want to hear yours. So Lunsford, good luck. You take care of yourself. Get a copy of today's order at the window outside the courtroom to your right, and take care of yourself.
See ya. Yeah.
And Happy New Year to you, sir.
There's Desiree Edwards is in the
Miss
courtroom.
Edwards, good to see you. That's how are you today? It's a little past 8:15, but we're still here, and you did show up. How are you? Well, so hopefully the year that just started now will be kinder and more peaceful to you. But it looks like what we're looking for is based on non-appearance, ordered a warrant for your arrest. We'll kill that. However, the issue still remains. Alcohol and Drug Information School. How about if we reset it over to February 13th? February 13th, will that give you enough time? Let's reissue. Yeah, these things, you're doing work crew, working off a deal there. That's get that done with. Get these things behind you. Get these behind you. One at a time. Let them drop off your record, and then of course stay out of trouble. Stay out of trouble, then you won't have these things to worry about. How's life going otherwise? Better, worse, about the same, kicking along. It's a new year and something to look forward to. Hopefully this year will be a good one for all of us. I'm signing the order now. Miss Edwards, what I want you to do is go to the window outside the courtroom, and that way, and instead of the other way, get a copy of today's order so you have a note of the date and time for the next hearing. Good luck with Pierce County, and you take care of yourself. Happy New Year. She did show up. February 13th. I guess I'm resistant to the calendar flipping over into another new year. Well, no shows.
Yep.
Let's see. Kevin Bingaman, I think we can start with.
Yeah, I mean, I don't have any way of, having contact with
no.
him.
City wish warrant for Mr. Bingaman, who so ordered, cash or bond. Mr. Ehrlich has been reset. That brings us up to, I think, the 11 o'clock calendar, Laura Gardner. Let's see if I can. One sec. Starting back on November 27th, was given a phone number, no good. FT8 on 12/5, number's still no good. I've never had contact with her outside of court. Warrant will issue 1,000 cash or bond for Laura Gardner. Mr. Higgins,
He's in the county jail,
he's in the
Or at least
jail.
was as of 2 days ago.
And he's got a new matter on our calendar as well as the old matters that he doesn't show up for.
Yeah, he's held on, let's see. Let's see. Oh, boy. Well, he's got in Superior Court, he's got a new possession of stolen vehicle, possession of controlled substance, knowingly, no prescription. I am tempted to, unless the city has an objection, just issue a warrant administratively for the two matters on the calendar, and then for the third that he won't show up for this afternoon. 1,000 each charge, cash or bond. Maybe things would have gone better if he'd actually complied with any treatment obligations, but who knows? Yeah.
And Amanda Eustace, guess what? She didn't show up again.
Shocked.
Miss Eustace. And the nature of her illness was too much New Year's Eve. She didn't get into that, but well, she did call.
I agree.
City has no objection. I'm inclined to set the matter over to note the non-appearance for speedy trial purposes, reset to convenience, 13th, 30th, whatever. Okay, yeah, 30th. And shock of all shocks.
I know.
Sarah.
I can't believe it. I really.
It's hard to believe that Sarah Shalhoub
I
did not
expect her
show
to
up.
be here.
Well, that's
I absolutely-
astonishing, really, just astonishing.
I'm astonished.
Have you had any contact?
You know, yeah, unusually, I haven't heard from him.
She was released on her promise to appear. City was your warrant. 1,000 cash or bond. On record, I'm going to call the 1 o'clock arraignment calendar. Before I call you up one at the time, I need to advise you of a certain number of things. This is your first court appearance. It's called an arraignment. You're here to enter either a plea of guilty or not guilty to the offense. The plea is invariably not guilty. The reason for that is there's a lot of ramifications to a criminal charge. You need to discuss the matter with an attorney and with the prosecutor prior to attempting any resolution of a criminal matter. You do have a right to have a lawyer represent you at all stages of a criminal proceeding if you're indigent. In any event, Mr. Haverco is going to enter a plea on your behalf today, regardless, and will, if you're indigent, represent you throughout the course of your proceeding. If you have any questions about your rights, about why you're here, about the charge you may have been cited for, ask either Mr. Haverco or myself. Starting at the top of the docket is Tasha Aronson in the courtroom. Mr. Aronson, if you'd step forward, please. And if you would have a seat next to the at the council table next to Mr. Haverco. Is your full name Tasha Marie Aronson? Maria? I'm going to mispronounce a lot of names here. If there's a way to mispronounce a name, I'm going to find out how to do that. The citation I have alleges that on or about December 24th, 2024, you committed the offenses of theft in the 3rd degree and criminal trespass 1st degree. Each of those is what they call a gross misdemeanor. The maximum penalty upon conviction would be 364 days in jail and or a $5,000 fine for each charge. At this point, I'll ask Mr. Haverco to enter a plea on your behalf.
Stipulate the probable cause, support to enter not guilty, please.
Aronson, probable cause just means that there is sufficient facts upon which the officer was justified in issuing a citation. What I want you to do at this point is to exchange contact information with Mr. Haverco.
Go ahead and write it down.
Ms. Aronson, we've set your pretrial for February 13th. I'm signing an order to that effect. I want you to, and I'll say this for the benefit of everybody here, before you leave, after your case is heard, I want you to go to the window outside the courtroom and to your right, get a copy of the order on today's hearing, and that'll have the contact information for Mr. Haverco on the today's order. Ms. Aronson, any questions? Conditions release or simply law-abiding behavior. And of course, appear for court when direct. Take care of yourself. Thank you, ma'am.
What's that?
Marcos Apodaca.
Yeah, if you want to use it, sure.
Good afternoon, sir. Is your full name Marcos, middle initial A, Apodaca? Citation I have alleges that on or about December 24th, 2024, you committed the offense of criminal trespass 1st degree. That's what they call a gross misdemeanor. The maximum penalty, again, is for that offense, 364 days in jail and or a $5,000 fine. I will appoint Mr. Haverco to represent you in this matter, and he's going to enter a plea on your behalf at this time.
Stipulate the probable cause, Your Honor, ask the court to enter not guilty plea.
Mr. Apodaca, plea of not guilty preserves your rights pending a pretrial, which will set for February 13th at 11 o'clock. Signing an order to that effect. What I want you to do now is give Mr. Haverco your contact information, if you would.
You have phone number? Oh, it's the same.
Any questions? That's good. Thank you, sir. All right. Thank you. See you back here in February. Shane Butler in the courtroom. Shane Butler. Did not appear. Number of people won't appear today. After I've talked to everybody here, I'll review the file to make sure there was probable cause to issue the citation. And that will result in a finding that a warrant should issue, and I'll issue a warrant for the person. So you've saved yourself a warrant by just showing up today. Next is Samantha Camille Franklin. Is Samantha Camille Franklin in the courtroom? Is not. How about Clayton Clark? Good afternoon, sir. Full name Clayton, middle initial S. Clark. Mr. Clark, you were cited for the offense of failure to transfer title within 45 days. That, believe it or not, is a misdemeanor. The city is nodded in my general direction, which means they are filing their motion orally at this time to reduce the offense from a criminal offense to a civil infraction. Here's the difference. With a criminal offense, if you're convicted, you can be put in jail. There's the possibility of jail time. With a civil infraction, it's a fine. There is no jail time possible, which means you're not entitled to a representation by a lawyer. The citation that you're now dealing with is one for expired tabs. If you admit you don't plead guilty or not guilty to an infraction, if you admit that your tabs were not in order on December 24th, I'll impose a fine in the amount of $150. If you deny that you committed any infraction, we can set the matter for a contested hearing. Now, do you have any question about anything I said? Do you wish to admit or deny? I will assess a $150 fine to the infraction. That failure to transfer title is still a criminal offense in Washington. It's one of 6 states. But I would get the title transferred as soon as you can. Signing an order, setting the fine and the payments, which will be $25 a month starting February 2nd. Please get a copy of the order at the window outside the courtroom to your left. And if you have any issue making any of the payments, let us know. We can certainly deal with that. If you stop making payments, we eventually notify the Department of Licensing, and then they send you a notice about your license. It's just not a good thing. So good luck to you, Mr. Clark. Thank you for appearing, and you take care of yourself. Jordan Cooley in the courtroom. Getting no answer. How about Mr. Alan Boots Dalton? Good afternoon, sir. Is that your full, true and correct name? Yep. Okay. Mr. Boots, you were, you were cited for the criminal offense of driving a license suspended or revoked in the 3rd degree. The city may have a motion in your case as well, and the city just did move to amend that case from a criminal offense to a civil infraction. If you were listening a moment ago, civil infraction doesn't bear any jail time. You either admit it or deny it. Your civil infraction now is no valid license on your person, no valid license, but identification on your person. If you admit that, I'll assess a $150 fine. If you deny that, we can set it for a contested hearing. Any question about what I just said? I'll assess $150 by way of a fine. For some reason, the officer didn't get your name quite right, but your last name is Mr. Dalton Allen is your full name. Mr. Allen, I'm sorry for that, but we'll get it figured out. Sign an order to that effect. And again, if you have trouble making the fine payments, let us know and we can deal with it, okay? And don't forget to get a copy of today's order. Order is now signed. Concludes the hearing. Mr. Allen, good luck. Take care. John Dees, D-E-E-S. Good afternoon, sir. Is your full name John Albert Dees? Mr. Dees, the citation alleges that on or about December 26, 2024, you committed the offense of knowing possession of a controlled substance. That charge is a gross misdemeanor. The maximum penalty on a conviction for a first offense would be 180 days and or a $1,000 fine. Mr. Dees, I'll appoint Mr. Haverco to enter a plea on your behalf at this time.
Stipulate probable cause as the court to enter not guilty plea.
Mr. Dees, a plea of not guilty reserves your rights. Excuse me. Conditions of release are no consumption of any non-prescribed substances of any kind and appear for court. Your pretrial is going to be February 13th at 11 o'clock. The order will reflect that. I want you to give Mr. Haverco your contact information, if you would. Mr. Dees, any questions at all? No, sir. Good luck to you, sir. Joshua Elmore in the courtroom. Is it Joshua Kyle Elmore? Mr. Elmore, you also were cited for the offense of driving a license suspended or revoked third degree. City may have a motion in your case as well, and indeed does. It's no longer a criminal offense. It's a civil infraction. If you admit the infraction, it's $150. If you deny that you committed any infraction, we can set it for a contested hearing. I'll assess $150 by way of a fine. Now, do you know what you need to do to reinstate your license? You'll have to check with the Department of Licensing. What it usually is an unpaid traffic ticket or so. And you have to bring that current or get that worked out. And also there may or may not be a reinstatement fee. But yeah, we live in a world where you pretty much have to be able to drive. Oh boy, I would make that a priority, getting your license reinstated. And the first person to contact is somebody at the Department of Licensing that can tell you what you need to do. So I'm going to wish you the best of luck. You take care. Get a copy of today's order at the window, and good luck getting relicensed. Take care of yourself, and you as well. Christopher Ferre, F-E-R-R-E. Does not answer. Come on up and have a seat. Question? At that window, we're shorthanded. Ordinarily it's that window, but today we're shorthanded, so it's to the right instead of the left. Good afternoon, sir. Is your name Christopher Jean-Paul Ferre? Go ahead and have a seat. Citation alleges that on or about December 28th, you committed the offense of reckless burning, second degree. Gross misdemeanor, the maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Averco to represent you and enter a plea in this matter on your behalf. Mr. Averco.
Stipulate to probable cause, that's the court to enter not guilty plea.
Mr. Ferre, plea of not guilty has been entered. We're going to set our next hearing for February 13th at 10 o'clock in the morning. I'm signing an order to that effect. What I want you to do is get a copy of the order at the window outside the courtroom and to your right. Okay? Any questions? Go ahead and give Mr. Averco your contact information, and that'll conclude the hearing. Sign on this. Sign on this. Mr. Ferre, thank you for appearing. You take care. Have a good day. Joel Glasser. Joel Glasser does not answer. Cornell Johnson. Likewise does not answer. How about Craig Gross? Dora Henson in the courtroom? Yes. Ms. Henson, if you would come on up and have a seat. And for the record, your full name is Dora Devine Henson. Evening. I apologize for mispronouncing that. Citation alleges that on or about December 27th, 2027, you committed the offenses of driving a license suspended, revoked third degree, simple misdemeanor, the maximum penalty, 90 days and or 1,000. You're also cited for failure to have ignition interlock when required to have that by law. Now that charge is a gross misdemeanor. The maximum penalty on conviction for that would be 364 days in jail and or a $5,000 fine. Mrs. Henson, I'm going to appoint Mr. Averco to represent you in these matters. He'll enter pleas on your behalf at this time. Stipulate to probable cause as the court to enter not guilty plea. Plea of not guilty preserves your rights, Ms. Henson. We're going to set the matter for a pretrial. You'll need to be here for that. And in the meantime, conditions of release are law-abiding behavior, and that would include don't drive unless you're licensed and insured, and if you're required to have ignition interlock, you're not to drive unless you have that installed. Any questions at all? No phone? Sensa, thank you for appearing. If you've given Mr. Averco your contact information, don't forget to get a copy of the order at the window. So, good luck. Timothy Higgins is not here for reasons discussed this morning. Paul Knapp. Paul Knapp in the courtroom. Having no answer. Jasmine McLaurin. Good afternoon, ma'am. Full name Jasmine Mariah McLaurin. That's it. Citation I have alleges that on or about December 26, 2024, he committed the offenses of assault and agreed at fourth degree domestic violence and malicious mischief, third degree. The assault charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Malicious mischief is a simple misdemeanor. Upon conviction for that, and that maximum penalty would be 90 days in jail and or a $1,000 fine. Ms. McLaurin, I will appoint Mr. Haverco to represent you in this matter. He's going to enter a plea on your behalf at this time.
Stipulate probable cause, ask the court to enter not guilty, please.
Plea of not guilty preserves your rights. Ms. McLaurin, a fairly standard condition of release in a charge like this is no contact with William David McLaurin while the matter is pending and until the order is changed. Any questions about the matter? You have a phone number?
So before you leave this, go over to the police department, we'll give you a copy of the ticket.
Lauren, thank you for appearing. You take care. We'll see you February 13th. Salvador Morales in the courtroom. Good afternoon, sir. Is it Salvador Demetrio Morales?
Yes, sir.
If I mispronounced that, I apologize. You were also cited for driving a license suspended or revoked third degree, which the city may have a motion and does. The criminal offense is now reduced to a civil infraction. Mr. Morales, if you admit that you did not have a valid license when you were cited on December 28th, I'll impose a $150 fine. You're also entitled to and have the right to deny that you did anything wrong, and we can set the matter for a contested hearing at a later date. Any question about anything I just said? Do you wish to admit or deny? Again, do you know, and this is the important thing, do you know what you need to do to reinstate? Oh, wonderful.
I didn't know.
That's one thing led to the other. That's and also that's the Department of Licensing. They send these, and I see this a lot. They send these notices out. Your licenses will be, but nobody tells the Department of Licensing when they've moved and gives them a forwarding address, and so it goes somewhere it shouldn't. So something to bear in mind: one, pay your fines or stay in contact with the court, but at least know when let the Department of Licensing know where you are. Mr. Morales, I'm signing an order to that effect. $150 fine, $25 a month. And again, let us know if there's an issue on that. But congratulations on being relicensed. That's great. That's always glad for me to hear. I like to hear that. You take care of yourself. I will. Michael Pendley in the courtroom. I didn't think so. How about Sandra Pratt? Good afternoon, ma'am. Is your full name Sandra Merlene Pratt? Ms. Pratt, it looks like you're in the same position. You were cited for driving a license suspended or revoked third degree. And the city is amending the charge to no valid operator's license on your person. An admission to that bears a $150 fine, or you're entitled to get a contested hearing at a later date if you wish. Any question about anything I just said? Do you wish to, excuse me, admit or deny? I'll impose a $150 fine, and your payments will be $25 a month. Now, do you know what you need to do to get your license reinstated? I'd make that a project in life. I'm not going to order and can't order you to do anything, but my suggestion is get your license reinstated as soon as you can. Signing an order to that effect, Ms. Pratt, I've done so now. What I want you to do is get a copy of the order at the window. And if you have any issues or any problems at all making any fine payments, let us know and we can deal with that, okay? Thank you for coming in and good luck to you. Take care. Dolly Rowlett. Good afternoon, ma'am. Full name Dolly Jolene Rowlett. Citation alleges an honor about December 25th, 2024. You committed the offense of driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. Ms. Rowlett, I'm going to appoint Mr. Haverco to enter a plea on your behalf.
Stipulate to probable cause, Your Honor, ask the court to enter not guilty plea.
Plea of not guilty preserves your rights. We'll set a pretrial. And Ms. Rowlett, conditions of release are don't drive unless licensed and insured. And very importantly, don't drink and drive. Any officer asks you to take a breathalyzer, you're to do so. Phone number? Rowlett, thank you for appearing. That concludes the hearing. Don't forget to get a copy of the order and we'll see you back here February 13th.
Yeah.
Thank you, ma'am. And you as well. Take care. Wendy Sasson or Sassoni? Hearing no answer. Nicholas Tejan? Hearing no answer. Diane Thomas? Good afternoon, ma'am. Full name Diane Ray Thomas. Citation, I'm looking at alleges that on or about December 24th, 2024, he committed the offense of DUI, driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverco to represent you in this matter. He'll enter a plea on your behalf at this time.
Stipulate to probable cause, Your Honor, ask the court to enter a not guilty plea.
Plea of not guilty preserves your rights. Ms. Thomas, I'm going to set some conditions of release. You do have a prior of offense of this kind quite a while ago, back in 2004. Some judges would already install ignition interlock. I'm not going to do that, but conditions of release are don't drive unless you're licensed and insured. No drinking and driving at all. Any officer asks you to take a breathalyzer, you're to do so. Any question at all? Ms. Thomas, good luck to you. You take care of yourself. We'll see you back here February 13th at 11 o'clock in the morning.
You don't need to write that.
You don't have to write that down. What I want you to do is give Mr. Haverco your contact information. Thomas, thank you. You take care. We'll see you back here February 13th. Don't forget to get a copy of the order. Thank you, ma'am. Kelly Wagner does not answer. How about Tina Wells? Good afternoon, ma'am. Full name Tina Monique Wells. As well as citation, I had alleged on or about December 22, 2024. You committed the offenses of DUI, driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You're also cited with driving a license suspended, revoked, third degree, simple misdemeanor. The maximum penalty on conviction for that would be 90 days in jail and or a $1,000 fine. I'll appoint Mr. Haverko to represent you. He's going to enter a plea on your behalf at this time.
Stipulate probable cause as 410 or not guilty plea.
Ms. Wells, a plea of not guilty preserves your rights. Conditions of release are law-abiding behavior, stay out of trouble, no drinking and driving at all. That's and if any officer asks you to take a breathalyzer, you're to do so. Pretrial will be February 13th at 10 o'clock, and I want you to give Mr. Haverko your contact information. He'll need to talk to you before court.
So yeah, just before you leave, just go to the police department window and I'll do the copy of the report.
Ms. Wells, thank you. You have a good day. Jared Wilson. Good afternoon, sir. Full name Jared James Wilson. Mr. Wilson, the citation is a familiar one by now. You're cited for driving a license suspended, revoked, third degree. The city may have a motion in your case and does. The charge is amended from a criminal offense to the civil infraction of no valid operator's license, second degree. If you admit that infraction, there's no jail time, can't be. I'll fine you $150. If you deny it, we'll set your case for a contested hearing. Any question? I'll assess a $150 fine, and of course I'll ask you, do you know what you need to do to reinstate your license?
Yeah, I've
Money.
been in that process.
Good. Time and money. Time and money. It's pretty easy to lose your license. A little harder to get it back eventually. I'm just going to wish you the best of luck with that. We're preparing an order to that effect. Now, I'd rather have you spend your money on reinstating your license. So if it's any issue at all, making the fine payments, let us know and we can deal with that, certainly. Absolutely. Mr. Wilson, take care of yourself and have a good New Year. Yep. I will. Good afternoon, sir. You came in late. I assume you had a matter on the calendar?
Yeah.
Last name is? Oh, yes, I think. Come on up and have a seat. Hey, that's Jordan Patrick Cooley, I believe. Mr. Cooley, the citation I have alleges an honor about December 18th, 2024. He committed the offense of driving a license suspended, revoked, second degree. Now that's a gross misdemeanor. The maximum penalty on conviction for that would be 364 days in jail and or a $5,000 fine. I'm going to appoint Mr. Haverko to represent you in this matter. He'll enter a plea on your behalf at this time.
Stipulate to probable cause, support that or not guilty plea.
Mr. Cooley, a plea of not guilty, does preserve your rights. You've indicated you reinstated your license or that's in the works.
Yeah, it's already reinstated, valid.
That can be verified.
Yeah, that is accurate.
You took care of that before court. We might be able to take care of that now.
Yeah, he actually was licensed. Perfect at the moment.
That's being verified. Quiet. No hurry. He is reinstated fully. That's if the city wants to amend it to no law, that's the city is amending the charge from the criminal offense of DDoS second as a gross misdemeanor, like 1 day less than a year in jail if convicted, but the city is changing the charge to the civil infraction of no valid operator's license on your person. A conviction for DWS 2 would likewise resuspend your license for a similar period of time.
Basically, my
No, the city, it would be if you were convicted of DDoS second, but the city, based on your reinstatement, has changed the charge to a civil infraction. If you admit the infraction, I'll assess a $150 fine, and the infraction doesn't affect your license. It's not suspendable at all. Any question about anything I just said? What would you like to do? Admit or deny? $150 fine is the penalty. As you now know, it's pretty easy to lose your license and an awful lot harder to get it back. Mr. Cooley, I'm going to congratulate you on getting your license back reinstated, and now that you have it, keep it. You've got responsibilities there. You can't lose a license when you have doctor appointments, et cetera, et cetera, et cetera, to make. Signing an order to that effect, Mr. Cooley, get a copy of the order at the window outside the courtroom to your left. And again, congratulations on getting reinstated, and you take care of yourself. Any questions? Have a good day.
I think we'll see the clerk over there.
That's it, yeah.
We have one more person in court, Mr. Cooley, on the calendar. Why don't you come on up? Sorry.
That's not Mr. Cooley. It's the individual we just talked to. It's and your name, sir, is?
Item number 3.
Going back, Shane Joseph Butler? Yes, sir. Mr. Butler, you were cited with the criminal offense of driving a license suspended or revoked, 3rd degree. That's a simple misdemeanor, the maximum penalty on conviction, 90 days in jail and or a $1,000 fine. City may have a motion and given the nature of the charge, the city is amending the charge from the criminal offense to a civil infraction. The difference is this: with the criminal offense, you can go to jail if you get convicted. Civil infraction, all I can do is fine you. That's and it doesn't have any impact. Well, the basic charge doesn't have any impact on your license. Now, what do you want? Well, is there any question about anything I just said?
Not necessarily about what you said.
Sure.
My buddy, he's kind of falling asleep. So that being said, when the cop got behind me because my buddy didn't have some vehicle, so he didn't have the plates because whoever sold it to him took the plates. He said it's not registered. I said, all right, it's fine. I didn't think that. Cop pulled us over.
Oh,
So that being said, like, not to say that I didn't do it intentionally or whatever. I mean, I didn't. But anyway, this is gonna keep me from getting my pistol rights back, which I've been good for 10 years, haven't got anything. Any other kind of charge on it, it will start my 10 years over. So if there's any way.
well, it's a civil infraction. It's not a criminal offense. And that's the difference. The civil infraction shouldn't have any effect on your gun rights. I can't guarantee I'm gonna be alive in 10 minutes. But no, I'll leave that up to the city if,
Like, he didn't have, like, I thought the police had to have a reason. Well, that's a reason, right? Because no.
oh, absolutely. He had a right to pull you over. Yeah, that gives a probable cause too. I've heard it said, and I believe it's true, you can't drive for a quarter mile and not commit some kind of an infraction or another.
I just pulled out a Safeway, he got right behind me.
Mr. Butler is concerned that he wants to get his gun rights back, and he's right at 10 years conviction free, and he's worried that an infraction might upset that. I don't see where it would. I don't think that does any effect.
I had a trespass that kept me from getting it this time until October.
When is it? You're up October of next year?
No, this past October is when I was.
You're able to
get the money to get, reinstated.
Well, I'm going to impose a $150 fine on an admission, but I will do this. If you find out that this does, I don't think it does. A criminal offense, yes, it would definitely do that. But a civil infraction, I do have some experience with reinstatement of gun rights. And I tell you this, if for some reason it does, I'll allow you to withdraw an admission and I'll consider a dismissal outright. If it causes you any problem, let me know. Just get a hold of us and we can, we'll deal with that.
And I'm not currently working right now, I just have my ACL repaired and stuff, so.
It's $150, and you can pay that at $25 a month. Would you be able to make a $25 payment by February 2nd? Well,
Can't take the possible.
I don't like possibly.
I don't either, but I don't want to see her lie to your face.
Let's see, let's go March 3rd. March 3rd, give you a little extra time. And your license, Mr. Butler, do you know what you need to do to reinstate your?
I believe it's child support. I don't see anything else.
Just the child support. I'd get that taken care of and get that back. But again, let us know if there's a problem with reinstatement. Again, don't believe there would be, but I can't guarantee the possibilities.
And I apologize for being late.
We were still in session, so no problem. Signing the order. Beller, go ahead and get a copy of it at the window outside the courtroom to your right. And again, let us know if it causes a problem, and let us know if you have any issues making the fine payments. If you let us know, we can certainly deal with it one way or the other. Good luck to you.
God bless.
You too. 2:30 here. On record for the 1 o'clock no shows. The first one I have is page 9 and 10, docket numbers 4, 5, 6, and 7. The new charge for Samantha Camille Franklin, I find probable cause for that. Although it was a minor case involving a cup of ice. 1,000 cash or bond. And on the other three non-appearances, 1,000 each. Next one I have is docket number 15. Oh. Joel Glasser, site of a DWS third, and failure to transfer title within 45 days, amend to no vault 2 and expired tabs and at FTA. Mr. Johnson, docket number 16, previously found probable cause for theft third on him when he was in custody. 1,000 cash or bond. Next, I have number 17, Craig Gross, amend DOS third 2, no vault 2, and FTA that. And 19, yes, go ahead and issue a warrant for Mr. Higgins, 1,000 cash or bond. Next is docket number 21, Paul Knapp, amend DOS third 2, no vault 2, and FTA it. And Michael Pendley, probable cause was previously found when he was booked into jail and released, 1,000 cash or bond. Next page, page 13, docket number 27, Wendy Sassone. Sassone, find probable cause for theft third, 1,000 cash or bond. Nicholas Tajon, docket numbers 28 and 29. FDA number 29. Number 28, amend DOS third 2, Noval 2, and FTA to the Department of Licensing. The last one, Kelly Wagner, we already reset her once for that her request and didn't appear again. So I guess just amend to Noval 2 and FTA. Yeah, that was, I thought there was that note in the file. I thought that was a little strange. And with that, we can go off Well, the 2:30 mitigation calendar, it doesn't look like Mr. Tim is going to show up. Go ahead and FTA his infraction. If he does, however, show up before the end of the day, for some reason we hear from, go ahead and reset. But if he doesn't, FTA.